You're sitting in a boardroom. The numbers aren't improving. The cash flow forecast that looked uncomfortable 3 months ago now looks alarming. Your bank is asking questions you don't have clean answers to. Your advisors are starting to use words like administration, receivership, liquidation. The room goes quiet. Everyone looks at each other. For most leaders, even experienced, accomplished ones, this is the moment the vocabulary stops making sense and the fear starts filling the gaps. Words that carry enormous legal weight get absorbed emotionally rather than analytically. Decisions get deferred not because the facts are unclear, but because the framework for understanding those facts simply isn't there. This video is designed to change that. Because understanding the formal insolvency framework isn't just for lawyers and accountants. It is for you, the directors, the board members, the senior executives who are responsible for making decisions when the stakes are at their absolute highest. The people whose names are on the filings. The people whose conduct will be scrutinized if things go wrong. Over the next 15 minutes, we're going to build your roadmap. We're going to demystify the legal landscape, clarify the procedures, explain who the professionals are and what they actually do, walk through the hierarchy of who gets paid and in what order, and most importantly, explain what the law expects of you, personally, when your company is in financial distress. This is not a legal textbook. It is a leadership briefing. And by the end of it, you will be equipped to engage with this process not from a position of fear, but from a position of understanding. Let's begin. Let's start with a fundamental clarification, because this point alone can shift the entire psychological frame of this conversation. Formal insolvency is not the same as failure. It is a legal framework, a structured, codified set of processes created specifically to manage situations where a company can no longer meet its financial obligations in the normal course of business. It exists in virtually every developed economy. It has evolved over decades. And it is designed not to punish, but to provide order. There are two primary legal tests that define insolvency, and boards need to understand both of them. The first is the cash flow test. Can the company pay its debts as and when they fall due? This is the immediate, operational test. It doesn't ask whether the balance sheet is technically solvent. It asks whether the company can meet the obligations in front of it, today and in the foreseeable future. The second is the balance sheet test. Do the company's total liabilities exceed its total assets? This is a more structural assessment, and it can be relevant even when a company appears to be trading normally, because off-balance sheet liabilities, contingent claims, and deferred obligations can tip the scales in ways that aren't always visible day to day. If the answer to either of these tests is yes, or is trending toward yes, the formal insolvency framework becomes legally relevant. Not theoretically relevant, not something to think about later. Legally and practically relevant, right now. And here is the single most important thing to understand at this stage. The law does not punish companies for becoming insolvent. Businesses fail for all kinds of reasons: market conditions, economic shocks, competitive pressures, over-leverage, bad luck. The law understands this. What the law does hold directors and boards accountable for is how they respond once insolvency becomes apparent. The decisions made, the advice sought, or not sought, the transactions entered into, the creditors paid and not paid. That is where personal liability is determined. That is where the scrutiny falls. That distinction, between the fact of insolvency and the conduct surrounding it, will define whether the directors of a failing company walk away with their integrity intact or face serious personal and legal consequences. Keep it in mind throughout everything that follows. Think of formal insolvency not as a single cliff edge, but as a landscape with multiple different paths. Some lead to rescue, some lead to orderly closure, some lead to value recovery for specific stakeholders, and some, the ones taken too late, or under compulsion, lead to the worst outcomes for everyone involved. The path your company takes depends on its specific circumstances, its assets and liabilities, the composition of its creditor group, and critically, the timing of when professional advice is sought. Administration is the rescue-oriented procedure at the heart of the modern insolvency framework. An administrator, a licensed insolvency practitioner, takes operational and strategic control of the company. Their primary statutory objective is to rescue the company as a going concern. Where that isn't achievable, the objective shifts to achieving a better outcome for creditors than an immediate liquidation would produce. Critically, administration triggers an automatic moratorium, a legal breathing space that stops creditors from taking action, enforcing security, or commencing winding up petitions. For companies with a viable underlying business, this breathing space can be transformative. And administration can be self-initiated by the directors, a degree of control that should never be underestimated. A creditor's voluntary liquidation, the CVL, is initiated when directors and shareholders conclude the company cannot continue. A liquidator is appointed to realize assets, pay creditors in the prescribed order, and ultimately dissolve the company. The word voluntary is important. A CVL is a decision made by leadership on its own terms. It is an orderly ending rather than a chaotic collapse. Companies that enter CVL proactively, when assets still have value and relationships are intact, typically produce better creditor returns, and their directors face significantly lower personal risk than those who delay. Compulsory liquidation is the procedure most boards want to avoid. A creditor, often a supplier, a landlord, or HMRC, petitions the court to wind up the company. A court-appointed liquidator takes over entirely. Director authority is extinguished. The scrutiny of conduct that follows is considerably more intense. Wide-ranging statutory powers allow the liquidator to investigate transactions, interview directors under oath, and bring personal claims. Compulsory liquidation is what happens when leadership waits too long, or avoids the conversation entirely. Receivership arises when a secured creditor, typically a bank holding a qualifying floating charge, appoints a receiver to enforce their security. The critical point boards must grasp is that the receiver's duty runs to that secured creditor alone, not to the company, its employees, or its unsecured creditors. In many jurisdictions, administrative receivership has been superseded by administration, but fixed charge receivership over specific assets remains common. Directors need to understand the security they have granted and the rights it confers. A company voluntary arrangement, the CVA, is not a terminal procedure. It is a legally binding compromise between a company and its unsecured creditors, approved by a statutory majority, that allows the company to repay a proportion of its debts over time while continuing to trade. For businesses with sound operations weighed down by legacy debt, a CVA can be a powerful tool. But it requires creditor confidence and realistic projections. A CVA proposed too late, or with terms creditors don't believe in, will fail, and a failed CVA typically leads directly to liquidation. Timing, again, is everything. One of the most disorienting aspects of entering a formal insolvency process is the sudden arrival of multiple professionals, each with their own mandate and their own relationship to your company. The insolvency practitioner, whether administrator, liquidator, or CVA supervisor, is a licensed professional whose primary obligations, once appointed, run to the creditors and to the court. Not to management, not to shareholders. The IP is not there to serve your interests or protect your legacy. Directors who understand this early avoid costly friction. Those who don't find themselves in an adversarial dynamic with the very professional they need to cooperate with. Restructuring advisors are the professionals you want engaged before formal insolvency becomes inevitable. They assess options, stress test cash flows, identify critical creditors, and negotiate with lenders on the company's behalf. Crucially, they work for you. Their mandate runs to the company and its leadership. Engaging them early, before options start closing, is one of the most consequential decisions a distressed board can make. Legal counsel is not optional, it is essential. Specialist insolvency lawyers advise on director duties, review transactions in the pre-insolvency period for challenge risk, advise on creditor rights, and manage the legal mechanics of whatever process is initiated. They are your primary line of defense if personal liability questions arise. HMRC and secured creditors are not neutral parties. HMRC holds preferential status for certain tax debts and has enforcement powers well beyond most trade creditors, including the ability to initiate winding up petitions and pursue directors personally. Secured creditors hold contractual rights that operate largely outside the general creditor hierarchy. Understanding who holds security over your business, and what that security entitles them to do, is not esoteric knowledge. It is essential board-level awareness. In any formal insolvency, assets are distributed according to a strict statutory hierarchy. This order cannot be altered by agreement or preference, and directors who attempt to circumvent it expose themselves to serious personal liability. Fixed charge holders are paid first, from the specific assets their security covers. Then come the costs and expenses of the insolvency process itself. The IP's fees and professional costs sit at the very top of the distribution waterfall, ahead of creditors. This consistently surprises directors encountering the process for the first time. Then preferential creditors, employees for certain arrears and HMRC for specific tax categories. Then the qualifying floating charge holder. Then unsecured creditors, suppliers, landlords, pension funds, sharing in whatever remains, often receiving pennies in the pound. And finally, if all creditors are paid in full, which is rarely the case, shareholders receive a distribution. In most formal insolvencies, shareholders receive nothing. That reality, once genuinely absorbed, should reshape every conversation the board has about what it is actually fighting for and when the point of no return has been reached. This is the part of the conversation that carries the most personal significance for everyone in that boardroom. When a company is solvent, directors' duties run primarily to shareholders. But as a company enters the zone of insolvency, that difficult, often ambiguous territory where solvency is genuinely in question, those duties shift. They begin to include, and ultimately prioritize, the interests of creditors. In practical terms, decisions that benefit shareholders at the expense of creditors become legally challengeable. Transactions that prefer one creditor over others in the pre-insolvency period can be unwound as preferences. Continuing to incur liabilities when there is no reasonable prospect of avoiding insolvent liquidation can expose directors to wrongful trading claims, with personal liability for the increase in the company's net deficiency during that period. And deliberate conduct designed to defraud creditors constitutes fraudulent trading carrying both civil and criminal consequences. The directors who navigate this period well are those who seek qualified professional advice and document that they have done so. Who hold proper board meetings, minute their reasoning, and record the information before them. Who act in good faith towards all stakeholders. The paper trail of good governance, board minutes, professional advice records, honest financial information, is the single most powerful protection available when conduct is later reviewed. Build that trail. Start building it today. Before we close, it is worth acknowledging what exists before the formal line, because for many distressed companies, formal insolvency is not the only option. Standstill agreements, debt for equity swaps, accelerated asset disposals, refinancing arrangements, these informal tools can resolve distress faster, more cheaply, and with less reputational damage than any formal process. They preserve confidentiality. They avoid the signal an administration filing sends to customers, suppliers, and employees. but they require the voluntary cooperation of creditors. And that cooperation depends entirely on creditor confidence in the information they're receiving and the management proposing the solution. Which returns us, as always, to the same imperative: the conversation has to start early. If there is a single theme running through everything we have covered, it is this: timing changes everything. Every week of delay in the zone of insolvency is a week in which working capital reduces, relationships deteriorate, key people leave, asset values erode, and the options still available quietly disappear. The boards that achieve the best outcomes, for their businesses, their employees, their creditors, and themselves, are those that treat early professional engagement not as an admission of defeat, but as an act of leadership. Formal insolvency does not have to be a fog of legal complexity and personal dread. It is a framework. It has structure, sequence, and logic. And like any framework, it rewards those who understand it, and punishes most severely those who approach it in denial, delay, or disarray. You now have the roadmap, the procedures, the professionals, the priority hierarchy, the personal duties, what the law expects of you, and when. That understanding is protective. It is the difference between navigating a difficult chapter and being defined by it. Financial distress moves quickly. The window to act, with options still open and choices still yours to make, closes faster than most boards expect. Equus Capital Finance works with management teams and boards to navigate exactly these situations. From early-stage restructuring advice through to formal insolvency processes, our team brings the expertise, the relationships, and the commercial clarity that leadership needs when the stakes are at their highest. Don't wait for the conversation to be forced on you. Visit equusfinance.com, or call us directly for a confidential, no-obligation discussion with one of our senior advisors. At Equus Capital Finance, we help you understand your options before they run out.